write down the three most, in your mind, the three most cherished rights that you hold most dear. Those rights that you have where you do not want the government to interfere with these rights. You could probably write down 20. But I just want you right off the top to pick out the three. For what three rights would you be willing to go out on Cabrillo and hold a poster? Or march for? Or object for? Because these are really important. And these are some of the things for which they're rioting in Kiev. That they don't have. And they want. And they're out there demonstrating. Fortunately, we don't have to demonstrate for most of them. But for some of them, people do demonstrate. And so I want you to write down those three which you most cherish, where there is an absolute conflict between one right and another right. And we look to the justices, the 9 justices of the Supreme Court, to finally decide when there is controversies across the land between these rights, because they're not self-exclusive. There are many times when one right conflicts with another. In this country, where there are some matters we don't vote on, that are not open to a vote, that it doesn't make any difference whether the majority feels so-and-so, they don't rule. And these are what we call the Bill of Rights, where a legislature cannot decide that tomorrow morning in Santa Barbara, no matter if they get 100% of the legislature voting so, that there's going to be a tax on everyone and the money collected will go to the Catholic Church. You can't do that, even though the majority would like them to. So there are those rights that we hold regardless of the majority. Some rights, these rights, we don't vote on. Riding the up escalator on the journey to equality over the past year were gay and lesbian couples and millions of folks who stoutly support same-sex marriage. For them, there was brilliant progress and redemption on an escalator at the court going up. Going down on the escalator were poor people, people of color, the elderly, and the ill. It was perhaps for those folks the worst year at the Supreme Court in half a century. So what's going to happen the coming year? During the coming year, the court is going to consider cases on marriage, surveillance, women's rights, money in politics, voting, and the right to habeas corpus, or not to be thrown into jail without charges and without a trial. That's the writ of habeas corpus that is occurring not only in the South Carolina prison, but at Guantanamo Bay. The hottest button presently is privacy. Now, before I get into privacy, I just want to take a smattering. Let me ask, someone raise their hand and tell me the 3 things that you wrote down in your card. Please, anybody. Yeah?
1, 14, and 4.
What are they?
Sorry.
Okay.
The first one is religion, no establishment of religion.
Okay, that's important to you.
Okay.
The freedom to pray the way you wish. Right? You don't want the government to have pray.
Exactly.
That's number 1 for you.
Exactly. And the right to be secure in your person, house, papers.
Okay, you don't want the police coming into your house.
That's right.
And 3?
And 14 is shall not deprive any person of life, liberty, or property without due process of law.
Okay, what does that mean to you?
It means that there's a legal system and the government has to comply with that and not.
Okay, go through due process of law that we expect. That's good. Somebody else? Anybody? Yep.
Privacy.
That's number 1.
Number 1. Speech.
Free speech?
Trial by jury.
Okay, that's fine. All right, someone else. Yes?
Cannot search one's home without a warrant.
Okay,
Freedom of religion.
okay,
Right to a jury trial.
okay. Somebody else?
Free speech,
I'm sorry?
free speech,
One that's free speech.
movement within the country,
Okay, that's good, yeah. The right to travel in any state you want. They can't tell you not to travel.
equality of all citizens.
I'm not sure what that means. Equality of what?
Have the same privileges and rights everyone does.
Okay. Equal protection of the law. Yep. Okay. Somebody, yes.
Gay rights, including marriage equality. Trial by jury of peers. Freedom from religion.
Okay. Okay. All right. So anybody else would like to? Yes. Linda, right?
Freedom of religion or no religion.
Okay. That's number one for you. Okay.
Freedom of choice with respect to abortion.
Women's freedom of choice. Okay.
Freedom of speech.
Free speech. All right. Yes, Lonnie.
My religion,
Religion, not free to pray or not to pray the way you want. You don't want the government interfering. Okay.
speech,
Free speech. Say what you want on State Street. Okay.
right to bear arms.
And what?
Right to bear arms.
Right to bear arms. Right to have a gun. Okay. Don.
Just add freedom of assembly.
And get free to get together like this class, and the government can't say that David Bisno can't talk to you about the government. I like that too. Now, it turns out that in the entire Constitution, the Declaration of Independence, and the Bill of Rights, the word privacy does not appear anywhere. You don't have any expectation of privacy whenever you use anything that is done digitally. Zero. So if you go on your computer, if you go on your cell phone, if you go on your computer, if you go, anything that you do that is done digitally, forget. The whole world can know about it. And so in thinking about this, if you really want to communicate with someone privately, you better take them to the park. Otherwise, it's all out there. I'm sure that many of you watched this confirmation hearing and came away with the, at least the appreciation that this John Roberts is a really smart guy. And a photographer snapped a picture of John Roberts exactly when Arlen Specter asked him the question, Judge Roberts, Arlen Specter asked, do you believe that the right to privacy exists in the United States Constitution? That was a pregnant question. That was a polite way of asking him about how he felt on the right to abortion without saying so. And Roberts absolutely understood what was going on. And do you remember what John Roberts said? Here he is. He looks a little pale right now because they were aiming with guns at him. And Roberts looked up and he said, Senator, I do. So he was put on record in front of the entire country, and everybody knew the stakes. What is the history of the right, the constitutional right to privacy? Because this has everything to do with Edward J. Snowden. And so to appreciate what's going on with Snowden, we need to appreciate the right to privacy. Originally, it didn't come from privacy. It was the word liberty. Liberty appears 3 times. Once in the Declaration of Independence, and twice in the Declaration of Independence. I've excerpted it. We hold these truths to be self-evident. The Creator was certain inalienable rights, and among these are life, liberty, and the pursuit of happiness. There's the word liberty. And 5th and 14th Amendments, which you have in front of you on your sheet, it states very clearly in the 5th and the 14th that no person shall be deprived of life, liberty, And why the 5th and the 14th? The difference and the reason is that the 5th Amendment bars the federal government from infringing on life, liberty, or property, but it doesn't say anything about the states. And up until 1865, the states were totally free to infringe on life, liberty, slavery, and property. After the Civil War and the passage of the 14th Amendment, when these words were put in, the 14th Amendment brings those same prohibitions against state governments. So no longer could state governments infringe on liberty. Okay, so what was the original meaning to the founders of liberty? The original meaning of liberty was freedom from bodily restraint or imprisoned by a government, because they had been traumatized in England, where the government could come in and grab you and throw you into a prison cell. And that's what they wanted to outlaw. So the original meaning of liberty was freedom from imprisonment. What the word liberty came to mean was not the freedom of imprisonment, but the freedom to form a contract between two people, or a business and a private person. And so if I go up to you and you are on hard times and need some food to feed your family and yourself, you're hungry, and I have this bakery shop and I make bread and rolls and bagels, right? But I need you to work, and I'm offering you a job, and I'm going to pay you 35 cents an hour, and I need you to work 12 hours a day. Will you take it?
Yes.
You will. Okay, he's hungry. He needs to feed his kids. And so you and I, let's shake hands, form a contract. I'm willing to pay you 35 cents an hour, and I need you to work 12 hours a day. And this gentleman's hungry, he has a wife to feed, and he agrees. That's a contract. He doesn't have to take it, it's no coercion. But neither do have any outside government or force telling us that we can't do this. And so we form a contract. That kind of a contract is what was meant by liberty. Liberty meant the right to form a contract free of a government interfering with that private right. The government might say, well, I don't think that people should work 12 hours a day, or you need to have a minimum wage of da-da-da-da-da, right? And that was found to be abhorrent. Louis Brandeis was a brilliant lawyer in Boston, fighting for progressive causes, and he wrote this article, this is 1890, entitled The Right to Privacy, which was the first document in the United States to talk about the right to privacy. And in this, he proposes a question. Should liberty protect more than the right to contract? Are there other kinds of rights that belong in liberty? And this paper calls for the protection of personal autonomy, a sphere of privacy. And in this article, the Harvard Law Review, December 15, 1890, was the document that put everybody in the country on notice that perhaps the word liberty should include more than the right to contract, but the right of privacy to be let alone from the government. Then we go to 1905. And in fact, this was the case which involved a baker in the Bronx. And the baker was making breads and bagels. And he wanted to do exactly what I offered you the job to do. He wanted someone to work 12, 15 hours a day, and they formed a contract. The baker's name was Lochner. The New York legislature decided to pass laws regulating the hours that you could hire someone and how much you needed to pay them. The baker objected. He said, this is an invasion of my liberty. I'm not hurting anybody. It went to the Supreme Court. And the case was Lochner versus New York. And the Supreme Court decided, what did they decide? In favor of Lochner or the New York legislature? They decided in favor of Lochner, the right to contract. That was the Lochner decision. Dissenting was Oliver Wendell Holmes from Beacon Hill in Boston. And as you will see later, and as often happens, a ringing dissent one year becomes the majority of the opinion, a majority of the court later. Holmes wrote, and I'm excerpting, the word liberty is perverted when it is held to prevent the natural outcome of a dominant opinion, i.e. the New York legislature, unless it infringes fundamental principles. So now you see the concept of liberty is enlarging. First it was throwing you in jail, and then it was right to contract. And now it's expanding in Oregon to how many hours a day you can work, women. And then in Nebraska, liberty is the right to teach and to learn. And then in 1928, in a case, Olmsted versus the United States, by this time, Brandeis is now on the court with Holmes, both from Boston. And this was a case that had to do with wiretapping. The court upheld the wiretapping that was done by the government. But Brandeis and Holmes both wrote ringing dissents, stating that this is an invasion of the privacy by the government about which I wrote in 1890. Now, at about this time, Holmes was approaching 92. He was the oldest justice to have ever served on the court. He was standing in the rotunda of the Supreme Court with one of the justices, and as they were having a conversation, a young secretary walks by wearing a miniskirt. And Holmes turned to his fellow justice, watched the secretary, oh, to be 70 again. 1937, this was a case entitled West Coast Hotel versus Parish, in which California had passed a minimum wage law for women. And that worked its way up to the Supreme Court. Was it constitutional to interfere with the right to contract? In a ringing decision, this is now 1937, it's done. In that case, the court wrote, the Constitution does not speak of freedom of contract, but it does speak of liberty, and prohibits the deprivation of liberty without due process of law. But the liberty, 3 times, Declaration of Independence and Constitution twice, but the liberty now becomes a new kind of liberty, no longer of contract, but of what has come to be known as fundamental values. Fundamental values. Guaranteed is the liberty to pursue fundamental values, including teaching, learning, occupation, hobbies, and the right for a legislature to pass laws for the public good. And the liberty from the government's intrusion into our, what is known as fundamental values. And so in 1942, in an Oklahoma case, what happened there was the Oklahoma legislature, in all its wisdom, had a series of criminals who had broken the laws, and they were found to be of low mental capacity. And they passed a law that if someone is judged to be of low mental capacity and commits so many crimes, we're tired of trying these people and putting them in jail and feeding them, and they don't deserve to have children because it's going to continue to promote mentally deficient people. And so if you're found to be mentally deficient in Oklahoma and you committed so many crimes, you have to be sterilized. That went up Skinner versus Oklahoma, and it had to do with the sterilization of criminals. And the court wrote, and they included the word marriage, but they said that marriage and procreation, the right to get married and the right to procreate, are fundamental values because you're a human being, and they are protected by the word liberty. That was a huge movement. Little did they know that the word marriage would come back, perhaps, to haunt this country. And then we skip forward from 1942 to 1965. Connecticut, in all their wisdom, a highly Catholic state, had passed laws making it illegal, and you could be arrested, if in any professional office, doctor's office, counseling office, social work office, you talked about or dispensed drugs having to do with contraception. That was illegal, because that was interfering with the Catholic Church's teaching. And they put that into state law. And that was challenged by a woman by the name of Griswold at the Planned Parenthood Center of New Haven. And that became the famous case, Griswold versus Connecticut. The decision there is the key decision that leads directly into Edward Snowden. Justice Douglas wrote the following: various guarantees in the Bill of Rights create zones of privacy. Now that is Douglas writing and essentially putting new words into the meaning of the Constitution. The right to learn, the right to teach, the right to procreation, the right to marriage, the right to intimate sex. The government doesn't belong in our bedroom. It doesn't belong in our study. It doesn't belong in our schoolroom. These are fundamental values, including the right to privacy. The next landmark case is Roe versus Wade, 1972, in which there is a really, really big debate. And when this finally worked its way up to the court, and Harry Blackmun was Chief Justice, he didn't know what to do with it. And so he took a vacation and went back to Minnesota from where he came. And he spent many months in the library of the Mayo Clinic, reading and reading and reading about pregnancy, abortion, etc. And finally came back to Washington and wrote the decision with many misgivings, known as Roe versus Wade, dividing pregnancy into first 3 months, the second 3 months, and the third 3 months. And that has been hotly debated and contested ever since. But his decision to uphold a woman's right, at least in the first 3 months, was based on her right to the privacy of her body. So now you get a feeling of the distance that privacy has come under the word liberty, and how that has changed. And then we go to just a few years ago. This is 10 years ago, when Texas, in all its wisdom, made it a crime for 2 gay men to engage in sodomy. This is their private bedroom, 2 consensual men having sex. It was illegal in Texas. And that case worked its way up to the Supreme Court in Lawrence versus Texas. And it was Kennedy who wrote the decision as you see here. Moral disapproval by the majority, i.e. the legislature of Texas, is not enough to justify discriminatory treatment of minorities, including gays and lesbians. The government does not belong in our bedroom. With that decision, privacy has taken its place in our society as a fundamental value, as part and parcel of liberty. Time and a retrospective view have shown and proven that those justices who felt otherwise have become disconnected from the locomotive of American history. Now, I'm going to stop there. We should take our break, and then we'll continue on the road with privacy. A couple of years ago, the police had reason to believe in the community that a person was a drug dealer. And they felt that they would be able to track down other drug dealers and round up a whole criminal conspiracy if they knew where to look and where the drugs were coming in. So unknown to this particular person who was under suspicion, the police attached a little GPS device under the bumper of their car. And all they had to sit back in their police station and look on their screen and watch where the car went. And the car, of course, eventually went out to this field to receive some drugs. And the police went out there and arrested the whole kit and caboodle of people. And you can imagine, how did you go to get there, etc. And Brandeis on the court had originally said in the Olmsted case back in 1928 that any evidence that is acquired by the police illegally cannot be used in court, because there is the transgression against our privacy. The police do have the right to go to court to get a warrant, but without a judge's approval that there's probable cause, if the police do that, any evidence that they seize cannot be used in court. And the police across the country were up in arms that we need to have these new modern devices to track down criminals. And perhaps our Constitution, our recent laws are not up to snuff with the advances in electronics. And so in this case, which absolutely Fourth Amendment case, you may think this doesn't occur often, but actually it does. That we had a 9-0 decision, a unanimous decision by the court. They're all feeling Justice Brandeis. They all knew the 1890 Harvard Law Review article. And they decided that attaching a GPS device to a vehicle without a warrant is an illegal search. And that was just 2 years ago. 9-0, which was a huge wake-up call to police across the country, that they cannot do this with impunity. Another case I can tell you about was that the police felt that people were growing marijuana inside their house against the state law. They didn't want to bother going inside the house, so they used infrared cameras to detect the heat. And apparently people need heat lamps. I can tell you I'm not an expert at this. And so the police were outside with their heat sensors, discovering what's going on inside the house. The same kind of thing without a warrant. And it could be that perhaps they don't know which house. They just go along the street with their heat lamps, their heat sensors. And a house shows up on their heat lamp. Aha, maybe they're doing something illegally inside. And here was another, Florida versus Jardines, had to do with dog sniffing. And the decision here was that bringing a dog onto private property. It was decided that in this case, bringing a dog onto private property without a warrant is an invasion of your privacy and violates the Fourth Amendment. And then King versus Maryland, which was just last year, the police, on arresting somebody for probable cause, wanted to swab the inside of the arrestee's mouth to obtain some DNA, and then go back to the police station and run the DNA through a database and find out what other crimes this person who drove across the yellow line or was caught speeding on. Is that an invasion of privacy? And the police, of course, arguing across the country, big testimony, big case, that this is part of now modern law enforcement. And I'm sorry, you legislators, if you can't write laws fast enough to keep up with hard technological advances in preventing crime and solving crimes that we would never have been able to solve otherwise. And so this was a very tough case. The court upheld the right of the police, finding that it's not any different than fingerprinting. Now here's the case to be decided, and this is going to occur, the argument is going to occur on April 29th. So write that down. So what this is about is whether a person who is arrested for probable cause, such as going across the yellow line or going too fast down State Street, the police stop you, and it is accepted that the police have a right to look around your car. And they have a right to look into any container in your car. You know, you're going 40 miles an hour in a 20-mile-an-hour zone, I'm going to arrest you and give you a ticket. You haven't been convicted. You either pay it or you go to court. But you're stopped for probable cause. The container has now morphed from a plastic vial that might contain some white powder of suspicious nature to a little flat thing called a cell phone. And that cell phone is loaded with information as to who you've called. And the question is, can the government, once you're stopped for probable cause, investigate your cell phone? Or does that violate the search and seizure restrictions of the Fourth Amendment? And that case is a really big hot case because everybody's walking around with these cell phones with a huge amount of information in it. And the case, there are two cases being heard at the same time, United States versus Rory and Riley versus California. One is a federal, one is a state, and the arguments will be on April 29th. So now, let me aim the conversation at Edward J. Snowden. And two questions come up, at least in my mind. Is he a criminal versus is he a hero? And we're going to get to that. What about the newspapers to whom this information is given, i.e. in this case, the Manchester Guardian and the Washington Post? And they published it, so the whole world read it. And in one instant, not only those in California or New York, but Angela Merkel in Germany learns that her phones have been tapped because it's published, not because the news, the stuff was stolen by Snowden and released by Snowden, but he released it to newspapers. And the newspapers made a calculated decision to publish it. And just as I want you to understand the path from liberty to privacy, so in discussing Snowden, which is yet to come up before the courts, is the problem of the challenge of what is known as prior restraint. And prior restraint means the government finding out that a publication, whether it's the New York Post, Time Magazine, or whatever, is going to publish an article, and the government doesn't want that article published. And so they go to court and get an injunction making it a crime for Time magazine or New York Times or Santa Barbara News Press to publish an article. And the history of this goes back to the time before this country was a nation. It goes back to colonial times. And the first case was that of John Peter Zenger, 1735. The court decided truth was a defense. Zenger had written the truth, and therefore he was not guilty. And the government could not prevent his printing the paper that he wanted to print because they were true. And they were true of a public official. And here's what John Peter Zenger looked like. This is 1735. That was the first case that established the right to not allow the government to infringe and put into practice prior restraint. What you do after it's published is another story. And so here we are, with back to the First Amendment. Congress shall make no law abridging the freedom of speech or of the press the right to publish. And so there are a series, but not very many, a series of major cases that set the scene for Snowden. The next was in 1931. We go from 1735 to 1931 in a case, New York versus Minnesota. A scandalous publication written by an outwardly anti-Semitic, anti-Catholic, anti-black minority hater. The government in Minnesota felt, we don't need this in the land of 10,000 lakes. And so they tried to prevent this fellow from publishing and went to the Supreme Court. The Supreme Court established that prior restraint violates the First and the 14th Amendment's liberty of the press. It's bad stuff, but the government cannot prevent its publication before publication. After publication, they can then sue for libel or slander or so forth. The one exception being, and they noted it there because this was after the First World War, that they could step in and prevent publication of troop movements, of things, of articles that might be published telling the enemy where we have the atomic bomb or where the ships are, movement of troops. That could be stopped. In 1964, in a case called New York Times versus Sullivan. And what happened here was the printed criticism of Alabama officials for mistreating civil rights activists. And Alabama didn't want this published. The court decided in this landmark case that a libel of a public official or a celebrity requires the following in order to find libel. The statement must be false. The statement must have caused harm. In this case, inadequate research was done to ascertain the truthfulness. And for a public official, the public official who doesn't like what's written about him or her must prove intent to do harm, had reckless disregard for the truth, and must prove malice. If there's an invasion of privacy, truth is generally not a defense unless it's a public official or a celebrity. So the paparazzi taking pictures of Jacqueline Kennedy topless in Monte Carlo on the beach, which is an invasion of her privacy by the press, could that be stopped? She's a celebrity. And everything that was photographed is true. And therefore, the court has decided that if it's a public official or a celebrity, the public is interested and has a right to know. Publication can go forward. Now, it's these cases of which the New York Times, the Washington Post, and the Manchester Guardian are fully aware. And you will not find in any publication that I've seen any mention of restricting publication of anything that Snowden has revealed. Remember Daniel Ellsberg? And we saw these, here's Daniel Ellsberg, Time magazine, when he was exposing the writings that revealed what really happened in Vietnam. And the Pentagon Papers, the publication, went up to the Supreme Court, and there was a 6-3 decision that the government effort to block publication was an unconstitutional prior restraint. And the publication of the Pentagon Papers was allowed. So there is a complete string of cases, all consistent with each other, upholding the right against governments putting into place prior restraint. And then we come to what the class today is all about. You recognize Bradley Manning, Julian Assange, Wikileaks, and everything that we read in the newspapers for the past couple of years. It's been argued that Wikileaks is a journalistic enterprise or a transparency movement, and the Espionage Act, which was claimed, has never been used against the press. You cannot go after the press for disseminating information, even if it is secret or true. In the case of Private First Class Bradley Manning, trivial leaks, none damage national security. Then we come to Edward Snowden. The first question was the right to publish, and the second question, is he a hero? And we've taken the first, the right to publish, and now we turn to, is Edward Snowden a hero or a traitor? Now we are going to have a debate. We are going to have a debate by two distinguished Vistas members. One is going to argue for and one against resolve that Edward Snowden should be the 2014 recipient of the Nobel Peace Prize.
This debate will make our democracy stronger, and as we are the model for democracy in the world, it will make democracy stronger overall, and for this, Edward Snowden deserves the Nobel Peace Prize. Thank you.
The question really, who is Edward Snowden? Well, he was a 29-year-old high school and college dropout, a computer nerd with a beautiful girlfriend who says he can wiretap anybody in the world, including the President of the United States. Now, I found this shocking. I mean, the idea of a computer nerd with a beautiful girlfriend.
Without Snowden, we'd still be in the dark. He's raised the issue, we're discussing it. People are demanding change. Change will happen. Our democracy will be stronger, we'll be a freer people, we'll set a better example in the world, and for this, Edward Snowden deserves the Nobel Prize for Peace.
And to really wrap it all up, I mean, the final argument is Peter lives in Santa Barbara and Snowden lives in Moscow. How could there be a choice?
Oh man, this is so good. I'm going to call him, have a repeat performance. So thank you both very much. Every day there are articles about privacy in one way or another. So I thought that our class is relevant. Now, as the case unfolds and moves up to the Supreme Court, you are going to hear about this case going back to 1979, and I want you to know about it. And the court decided in that case that United States citizens do not have a reasonable expectation of privacy for information that they have exposed to a third party. And just recently, we have two federal court judges who absolutely blatantly disagreed with each other. And this made big, big news. Judge William Pauley for the U.S. District Court in New York found that the NSA collection of data is legal. And Richard Leon, who is with the U.S. D.C. Circuit Court, which is a higher court, but it's still a different federal court, and Leon has a reputation for being very conservative, normally, came down with a ringing decision that blew everybody out of the water in Washington, that what the NSA doing in collecting our phone data is illegal and violates the Fourth Amendment of the United States Constitution. So it is these two decisions which are going to force the Supreme Court to take on the case of whether what NSA doing is legal. Finally, I want to throw this question out to all of you. Snowden is in Moscow, and we have Amanda Knox found to be guilty in Italy of murder, but she's in the United States. Washington, D.C. would like Snowden extradited to this country. Italy would like Amanda Knox extradited to Italy. Is there a commonality between the two? And what might you conclude from these two cases? What is the tie?
We have an extradition agreement with Italy. Sure.
Yes.
Yes, we do. If we do, then we should honor that.
So by not sending Amanda back, is that an example for Russia to say, well, look, if you don't return Amanda, we're not going to send Gordon Snowden back?
Do we have an extradition agreement with Russia? Honor it.
Well, okay, so is there a parallel?
Snowden has never been tried in Russia or in the United States. So I think there is, I'm not too sure the parallel is there.
It was suggested to me that we don't think much of the Italian justice system. And so therefore, just as the United States has chosen not to extradite Amanda Knox because we don't like their justice system, Russia may be saying, we don't want to Edward Snowden, we honor our treaties, but we don't like the justice system that the Obama Justice Department is suggesting for Edward Snowden. The court's decision about what NSA is doing, whether legal or illegal, is really separate and aside from what Snowden did in taking the data and sharing it.
You take the music. You are putting yourself on the line to say, this is wrong, and take the consequences. He became a fugitive.
Snowden wants to keep all of us safer from our own government, as Peter explained to us.
That puts our own nation in peril, our defenses.
That's what the Obama administration is arguing. Exactly. Next week, guns. Okay. So we'll be looking forward to seeing